All right, we're back on the record. Ladies and gentlemen, let me address the issue that we have before us. Pardon me. First thing I would deal with is the issue of the letter that has been submitted by the defendant as mitigation evidence. And they cite the case of State versus Cawthorn, which is a 1998 case, 967 Southwest 2nd, 726. In that, the defendant was denied the opportunity by the trial court to introduce a letter from his son. It was a death penalty case, and it said, the letter said the following: "Dear Dad, I love you, Dad. I hope I come again. I hope I come again. Jen," I think that was misspelling. "Sometime we went to Chuck Cheese, we went to Walmart, and we had fun. Love always, Ryan." The trial court had excluded the letter, finding it was negligible probative value and was cumulative to the other evidence presented. In any event, the Supreme Court reversed that death penalty and vacated it and sent it back for a resentencing because of the exclusion of that letter. And it went on to say that they've stressed that Article 1, Section 16 of the Tennessee Constitution requires that the jury not be precluded from hearing evidence about the defendant's background, record, and character in any circumstance about the offense that may mitigate against the death penalty. The court went on to find that that was harmless error because there was evidence in the record that the defendant's family and young son had expressed love and support already for him. This letter that has been submitted to me basically contains a statement about this child's relationship with his father. It goes on to say that, talk about the events, and he goes on to say, if he got sentenced to death, it would rip my little heart in half. And then he said, I never saw the bad side of him. And it goes on to talk about the events of the actual offense. There is a difference between victim impact statement and mitigation evidence presented by the defendant. Whether that makes a lot of logical sense to people or not, I can't help. The Supreme Court has differentiated between those two. In mitigation evidence, it is evidence that the defendant can produce that is produced in an effort to show reasons why the death penalty should not be imposed. The victim impact statement cannot include a request for a particular sentence to be imposed, but it can include statements of the love and affection and the impact that the crime had upon the life of the family. Mrs. Baker gave a very passionate and eloquent statement and recited the effect it's had on this child and the love and all of that she detailed in detail about the child, using the phone to call her father at night and so forth. And that was, I think, an appropriate victim impact statement, and I found as much. But what this court is required to do is to adhere to the requirements and the limitations that are put upon me as a trial judge in allowing certain types of evidence. Therefore, I will allow portions of this child's letter to be introduced to the jury, and I believe, have you given a copy to the other? And what I've done is I have had a copy of the letter that has been redacted to omit those portions that I found would not be appropriate, so that the portions that would be allowed are as follows. I don't know much about my father, but I know for a fact that he loves me. When I think of my father, I remember his big hugs in the morning the most. I remember feeling the warmth and the tightness of them. They made me feel safe. And then I would allow the signature at the end. The portions that I have omitted, in my opinion, are those portions that deal with the details of the crime, his feeling towards his father about having been told the nature of the crime and what took place. And in fact, it makes a statement in here that he would like to punch his father in the face and asking him how could he have done such a terrible thing to another person. So under those circumstances, it is my opinion that those portions that I have detailed would be allowable, and they would be either read to the jury or this redacted portion can be introduced if that's what the defendant wants. But that's my ruling on that particular issue. And I know that the state had indicated you wanted to introduce a letter from Daniel Baker's child, and as I've said before, the victim impact statement that was produced at the state's proof is what I can allow under the law and under the Supreme Court's ruling. I don't know that I can allow a second victim impact letter from the child to be introduced, even if it's identical to the one that we've just talked about. I see no authority in the law that allows me to do that, but go ahead.
Your Honor, may the state make an offer of proof, because it's our position that under the law, excuse me, and under 3913-204, in the sentencing proceeding, evidence may be presented as to any matter the court deems relevant to the punishment and may include, but not be limited to, the nature and circumstances of the crime, the defendant's character, background history, physical condition, any evidence tending to establish or rebut the aggravating circumstances enumerated in subsection I, and any evidence tending to establish or rebut any mitigating factors. So the video that we are making as an offer of proof would be to rebut this letter. I mean, the law clearly says any evidence that tends to prove or to rebut a mitigating factor. So if the court is allowing this letter in as a mitigating factor or mitigating circumstance, then this offer of proof and this proof would be to rebut that. And I would play this video now through Mr. Etheridge.
All right.
Where do you want to go?
To heaven.
What?
Because when I really want to see Daddy, I would jump off the moon.
You're going to jump off the moon and see Daddy?
Yeah.
No, I wish you could, but once you go to heaven, you don't get to come back.
I would jump off the moon.
The moon is really far up.
And I may jump really far up.
Yeah.
I did a video.
Yeah.
Judge, I'll move this as exhibit. Stands on.
Right, that's made as an offer of proof, and of course we're not yet to the rebuttal stage, so we'll consider that offer of proof at the appropriate time. Anything else then before we bring the...
Yes, sir, Judge, I intend to cross-examine the current
All right.
witness with two phone calls that have...
Then let's have Mrs. Wiggins return to the stand, and I would remind you, Mrs. Wiggins, that your testimony remains under oath. Hold on just a second before we proceed. Since this has made an offer of proof, we're going to reserve marking that video until it becomes a point where you're actually offering rebuttal proof, so that it can be marked as logical sequential order. So just hold it for right now until we get to that point.
Now, the defense letter, is that 278 that you have?
We haven't introduced that yet.
Okay.
We will, when that comes in, it will be the next in order.
All right, thank you.
May I begin?
You may.
Good afternoon, Ms. Wiggins.
Hi.
Before we broke for lunch, part of your testimony included that you had communications with the defendant, your son, as he was incarcerated. Is that correct?
Yes.
How do you speak with him when he's incarcerated?
I either go visit or on phone.
Ms. Wiggins, if you'll remove your mask, please.
Oh,
and
I'm sorry.
Be able to make sure we can pick up everything you're saying. Thank you.
Let me go back. How do you communicate with the defendant as he's in jail?
Phone calls, visitation, and text.
Okay. And how do you text with the defendant? Does he have a phone inside the jail?
Oh, no. It's through an app.
Okay. An app that the jail provides?
Yes.
That the inmates are allowed to use?
Yes.
Okay. And then he is also, meaning your son, allowed to use the phone and make calls, is that correct?
Yes.
And you have spoken to him several times on those phone calls?
Yes.
Did you know those phone calls are recorded?
Yes.
All right.
It says it at the beginning.
It actually says that they're recorded.
Yes.
And on some of the phone calls, did you allow Spencer to speak with the defendant?
Yes.
Okay. And I'm going to ask you if you can recognize this call.
Hey, guess what?
What?
Mama is pregnant.
Do you recognize that voice?
It's Spencer.
That's
I'm
Spencer.
not sure what he said.
Okay, back it up. And what we've done is we've taken a clip from one of the phone calls. Go ahead.
Hey, guess what?
What?
Mama is pregnant.
Oh, I know what he said.
Mama's pregnant.
We'll kick her in the stomach.
Could you hear that? Well, what did Spencer tell the defendant?
That his mama was pregnant.
And what did the defendant tell Spencer?
To kick her in the stomach.
Okay, that would be my questions.
All right. Any argument about that line of questioning before we have the jury in?
Yes,
All
Your
right,
Honor.
let's hear it.
Your Honor, I think it's appropriate for cross. I don't think it's appropriate for cross. It's not probative of anything. The sentencing statute that's the issue. Is it probative? What's it probative of? As to her testimony, how is it a proper cross-examination of her? It's a call. There's no indication she's on it. No indication she heard it. And even if she did, what's it probative of? It's intended to be shown for the prejudicial effect of it. And based on the limited probative value that it shows and the possible prejudicial effect, I don't think it should be allowed to be played to the jury. And I don't think it would be appropriate to put it in through her either.
All right.
Your Honor, the court has just allowed the defense to enter a letter from Spencer to his father in jail as a mitigation piece of evidence. Exhibit 264, which I pulled for the court. Exhibit 264, would you hand that to the judge, please? As part of the defense's mitigating proof, Exhibit 264 contains multiple communications by and through the current witness, Ms. Wiggins, to the defendant as he's incarcerated through the kiosk or the app that she just described that allows communications. She's relaying these messages, which is completely fine. I mean, everybody knows they're recorded, but these communications through Spencer to the defendant and vice versa, and the point of which is to be mitigating, to show the love between the defendant and his son. Well, this call that we're proposing to introduce rebuts that. You don't tell your son that you love to go to his mother and kick her in the stomach when she's pregnant. I mean, this is clearly rebuttal proof. I mean, the entire purpose of mitigating evidence is to mitigate something. Now, they haven't listed it under any particular factor, so it just falls broadly into any other mitigating factor. But the whole point of it is to establish a loving relationship between the defendant and his son. And this directly rebuts that. Someone you love, you don't tell them to go kick their mother in the stomach while she's pregnant, or ever.
Your Honor, it's absolutely not rebuttal. It's not proper rebuttal because it doesn't, what's in this letter, what's in proof is that Spencer loves his daddy. What's in this letter is talking about that he loves his daddy. He loves me. And he goes in when he remembers about his father. This call doesn't rebut any of that. It doesn't rebut the messages that were put in the kiosk. I mean, it doesn't rebut any of those things. It's not a proper cross-examination. I mean, and to take this call is not relevant to anything. It's not relevant to either factor, and it's not relevant to anything we've put in play.
Well, have you been attempting to prove that there was a close bond or relationship between Mr. Wiggins and his son?
Yeah, but
by this testimony?
Absolutely, but close bond has nothing to do with good parent. I mean, that's what he's arguing. He's saying, what parent would say that? Not one witness has come in here and tried to critique his parenting skills. If we'd done that, we'd have put it at issue. But we didn't. So for those reasons, Your Honor, we don't believe it should be allowed. And it's a snippet of a call. The call that when we listened for this purpose the other day, there was a beginning of the call where he was talking about, I started school, how'd you do in school? Well, how was school? And he's talking to him about that right before this interaction. I mean, Your Honor, that, like I said, the probative value, the lack of context, was it in, I mean, it shouldn't be allowed.
Well, the problem that we have here is that it does present the potential danger of constituting an aggravating factor for the jury to consider that's not a statutory factor. And I have to weigh the prejudice versus the probative value. But more importantly, in this case, at this juncture of this case, this witness is not privy to that conversation, and all she can do is identify the voices in it. This recording may very well be relevant. It may very well be admissible through a different witness at a later time. I'm not ruling on its admissibility at this point in time. I assume to rebut part of the evidence of the good love and good relationship between this defendant, but there are other allegations that are being made about Mr. Wiggins and so forth that we, once the defense has concluded its proof, I'll consider whether or not it may be admissible on some other basis. But I think at this juncture with this witness that it would not be appropriate to allow this evidence in at this point. So I will sustain the objection as to this witness's testifying about it. Now, when the jury returns, then Mr. Evans will be allowed to continue his questioning directly of Mrs. Wiggins and introduce this redacted letter if he chooses to. And you can either read it to them or you can introduce the redacted copy. They're going to obviously know there are portions that were redacted if you do that. All right. Anything then before we bring the jury in? Anything else?
No, Your Honor.
All right. Then let's bring the jury in. Thank you, ladies and gentlemen. I believe, Mr. Evans, you are continuing with your examination of this witness.
Hey, Ms. Wiggins. So, recently, did Stephen's son Spencer write a letter to him?
He wrote a letter. He gave it to me and asked me to read it in court if I could.
I'm going to pass you a copy of that. And I'm not asking you to read it at this point. I just want you to tell me if you can identify it.
Oh, yeah.
You know,
It's hard to read because Spencer sort of makes the whole thing sort of one word from the beginning to the end.
and if you can pass that back to me. And you've reviewed it, right? You've looked at it. And I want to read it aloud, and you can tell me if it's accurate, okay? I don't know much about my father, but know for a fact that he loves me. When I think of my father, I remember his big hugs in the morning the most. I remember feeling the warmth, and the light.
Tightness, I think.
The warmth and the light of them. They made me feel safe. And is that his signature, Spencer J. Wiggins?
Yes.
Your Honor, I'd ask this to be made the next numbered exhibit.
All right, mark it as an exhibit. Ladies and gentlemen, in your absence, one of the reasons we were later getting started than what I told you, I had considered portions of this letter that, in my opinion, as I've explained to you, contained information that I do not believe was appropriate for a sentencing hearing. For that reason, I have ordered that that letter be redacted, and those portions that I found were not admissible were excluded. Thank you.
Your Honor, once it's entered, I'd ask to be published to the jury.
That's fine. You can pass that to the jury after it's marked. Madam Clerk, what are we up to now?
278,
278?
8. Yes, sir.
Counsel approach the bench. This doesn't have to be, I'm going to have an unredacted copy of this for identification purposes. I'm going to do so for records clear with all this.
I would ask you to keep that copy again. We'll modify copies as well. Yes, sir.
Madam Clerk, we'll do the mark these two copies. This is for identification purposes.
A and B.
All right, Mr. Evans, the jury has reviewed that exhibit.
Thank you, Your Honor. Ms. Wiggins, I may have asked you this already, but since the break, I just want to make sure I did. How old is Spencer?
10.
Thank you. Those are my questions, Your Honor.
State have questions? No questions. Thank you, ma'am. You may step down. You may sit in the courtroom or you may leave if you'd like. Mr. Evans, you have additional witnesses?
Yes, Your Honor. I would call Lieutenant Kenneth Drake.
Would stand right here, face the clerk, raise your right hand, be sworn.
Do you solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am. Have a seat in that chair, speak directly into the mic.
Good afternoon, Lieutenant Drake.
How are you, sir?
I'm doing well. I'm doing well. Would you please state your full name for the benefit of the jury and the court reporter and spell your last name?
Kenneth Drake, D-R-A-K-E,
And where are you employed?
the Robertson County Sheriff's Office Detention Facility.
And how long have you been so employed?
Almost 13 years.
And to your knowledge, has Stephen Wiggins been housed at the Robertson County Detention Facility on this case?
Yes, sir.
All right. And for approximately how long to your recollection?
Somewhere around 2018. I don't know exactly when, but I do know it was sometime shortly after.
And what do you do at the detention facility?
I'm the administrative lieutenant.
And in your role as the administrative lieutenant there, have you had calls to interact with Mr. Wiggins?
Yes.
All right. And based on those interactions and the information before you, how would you describe him as an inmate at the Robertson County Jail?
Basically a model inmate.
Give you any trouble?
No, sir.
Those are my questions.
Cross-examine?
No questions.
Thank you, sir. You may step down.
Thank you.
You may call your next witness.
Yes, Your Honor. The defense will call Patrick Traughber.
You would stand right here, face the clerk, raise your right hand, be sworn.
Do you solemnly swear or affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
I do, ma'am. Thank you, sir.
Good afternoon.
Good afternoon.
Please state your full name, spelling your last for the benefit of the jury and the court reporter.
Patrick Royce Traughber, Traughber.
Thank you. And it's Traughber?
Yes, sir.
All right, make sure I say that right, okay. So, in your, what do you do for a living?
I'm the sergeant at Robertson County Sheriff's Office,
All right.
Corrections Division.
And how long have you been so employed?
9 years.
All right. And during your employment, have you had calls to know Stephen Wiggins?
Yes, I have.
And has he been housed at the Robertson County Jail in this case for some period of time?
Yes, sir.
And about how long to your recollection?
About 2.5 years, I think.
And Sergeant, during that time, have you had contact and interactions with Mr. Wiggins?
Yes, I have.
And based on your interactions with him and what you know about his conduct at the jail? Do you know him? How would you describe him as an inmate?
A compliant inmate. He's followed all the rules we put forth with him and followed all directions we gave him.
All right, thank you. Those are my questions.
Questions from the state? Thank you, sir. You may step down and you are discharged. Mr. Evans, you may call your next witness.
May we approach?
You may. Ladies and gentlemen, if you'll step across the hallway, I need to take up some matters outside your presence. Mr. Evans, do you want to consult with your client in private at your request? All right, ladies and gentlemen, in order to allow the defense to consult with Mr. Wiggins in private, we will take a recess. I assume it doesn't need to be extremely long, is that correct?
That's correct.
10 minutes or so?
Yes, Your
All
Honor.
right, we'll be in recess for 10 minutes.
All right. This court is in recess. Back in session. You may be seated.
All right, Mr. Evans, before we bring the jury back, is there anything else we need to address?
Yes, Your Honor, we would need to conduct a Beaumont hearing.
All right, Mr. Wiggins, if you'll come around, please. And again, if you'll go to the witness stand and let the clerk place you under oath.
Do you solemnly swear or affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, Stephen, did we just now talk about the fact that you have a right to testify on your own behalf or not to testify in the sentencing hearing?
Yes, sir.
And we've talked about that before as well, have we not?
Yes, sir.
And along with Mr. Simmons and Mr. Hopkins, right?
Yes, sir.
And based on that conversation and everything that you understand, do you understand that you have an absolute right to testify on your own behalf if you choose to do so at this sentencing hearing?
Yes, sir.
Alternatively, do you also understand that you have an absolute right to never testify or never say a word on your own behalf at this sentencing hearing?
Yes, sir.
And knowing that, do you choose not to testify?
Yes, sir.
Has anyone forced you or coerced you into making this decision, or was it on your own?
It was on my own.
Is there anything you don't understand about the right?
No, sir.
Right. And you're waiving that right?
Yes, sir.
And you're waiving it knowingly and voluntarily?
Yes, sir.
All right, let the record reflect the defendant has knowingly and voluntarily waived his right to testify at the sentencing hearing. So, Mr. Wiggins, you may return to the counsel table.
Your Honor, that being the case, the defense would now rest when the jury comes back out.
Mr. Evans, is there any reason on the record that you believe that your client, for any of the reasons that have been introduced at the sentencing hearing, that there would be any reason that mentally he would not be able to or confident to make this decision?
No, Your Honor.
All right, let the record reflect that. Then we're going to bring the jury back, and when we do, at that point, we'll ask you if you have any additional witnesses and allow you to rest your proof.
Thank you, Your Honor.
Then I think at that point, the state will have the right to make any sort of rebuttal proof that you wish. Is that correct? All right. And we're ready for the jury.
Yes, sir.
Are we going to have any jury out here regarding the state's proof? Yes?
Yes.
You want to take those up now?
Well, Judge, based on your prior rulings, you need to hear some testimony. We can go through the first witness.
Welcome back, ladies and gentlemen. Mr. Evans, you may call your next witness.
Your Honor, that's all the witnesses for the defense. The defense rests.
All right, the defense rests for purposes of the sentencing hearing. State, have rebuttal proof you wish to call.
State calls Agent Crawford.
It's just not here.
You would stand right here, face the clerk, raise your right hand, be sworn. Yes, sir.
Do you solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
Signature right there, speak directly into the microphone.
Yes, sir.
Good afternoon, Major.
Good afternoon.
For the record, are you Major Tony Crawford?
Yes, ma'am.
And Major Crawford, could you please say and spell your last name for the court reporter?
Yeah, the last name is Crawford, Crawford.
And your first name is Tony?
Tony,
Common spelling?
Tony.
Thank you. And Major Crawford, how are you currently employed?
I am the jail administrator for Robertson County.
And how long have you been the jail administrator for
11
Robertson?
years.
And how large is the jail in Robertson County?
588 beds.
As part of being in the jail, are there specific rules and regulations?
Yes, ma'am.
And could you give a sort of a brief description of what rules and regulations there might be?
There's probably 16 pages of rules and regulations that each inmate gets when they come into jail. There's an inmate handbook. We'll have all of the rules and regulations spelled out in the inmate handbook.
Okay, so the inmates are aware of what the rules and regulations are?
Yes, ma'am. It's issued to them. It's also on their kiosk. They can pull it up anytime and review it.
Okay.
You may. All right. Thank you. General Secretary, you may proceed.
Thank you. So Major Crawford, as you were saying, there is I think what you said was about a 16-page
I believe that's
list
right.
of rules.
It's not all just rules of procedures also. Okay,
Thank you. And that each of the inmates has a copy of it, and then they also have access on their kiosk.
Yes, ma'am.
Okay. Is one of those rules that they're not allowed to be tattooed while they're in jail?
Yes, ma'am.
I'm going to talk about this briefly with you. Was Robertson County Jail housing the defendant, Mr. Wiggins?
Yes, ma'am.
How long approximately have you been?
I think it's just over almost 2.5 years.
A fairly lengthy period of
Yes,
time.
ma'am.
Okay. And did it come to your attention that Mr. Wiggins has violated that rule?
Yes, ma'am.
And upon learning about that violation, what course of action did you take?
We had a shakedown of the unit that he was housed in.
And what did you find?
I believe they, as best my recollection, it's been quite a while, but that they recovered 2 tattoo guns that day.
Okay. And were they?
They're homemade guns. That's terminology we use.
And this probably goes without saying, but they're not allowed in your facility.
No, ma'am, they're not.
And were they found in the same cell that he was?
I don't remember if they were found in his cell. I don't recall that, but I know they were found in the cell block.
Okay. And to your knowledge, did he receive tattoos that he was not allowed to receive in that jail?
Yes, ma'am.
Nothing further on.
Questions? No. Thank you, officer. You may step down, you may leave, or you may stay around if you like.
Thank you, sir.
All right, the next witness is the next matter is when we need to take our jury out here. Ladies and gentlemen, again, the procedural issues require me to have you exit the jury room, or exit rather the courtroom and go to the jury room while we deal with some other matters. If you'll step out, please. All right, at this point, the defense has filed with the court a list of mitigating factors that they're going to ask that be submitted to the jury in consideration, for their consideration in sentencing, since the defendant's proof would be regarding the mitigating factors that they allege, as well as the state's rebuttal proof will be to rebut any of that evidence, then we'll need to necessarily, so that the record is clear, that the state has not been entitled to see that list of mitigating factors until the defendant closed its proof at the punishment phase. So now they're going to be given a copy of those mitigating factors, and they'll necessarily need some time to go over them and then be prepared to use their proof, if they choose to try to rebut any of that evidence. So with that, we'll give you a copy of that. Was there another matter that I need to take up while we have the jury out? Or do you want to look at this list before we take that up?
We'd like to see the list, Your Honor.
All right, let's give you a recess to allow you to do that, and then we'll come back as soon as you're able to adequately review their list of mitigators. And or do you want to give them a copy of how we're wording it, or are you still working on those? Doesn't matter to me. Let's give them a copy of what Mr. Evans has requested. I will state that we're working on wording the mitigators that they're alleging in a fashion that that more comports with what I think the statutory language would require. So, all right. We'll stand in recess.
All right.